All right, everybody. Welcome to the Creative Finance Collective. We get together every week and to talk about creative finance and take your questions. We got a few folks joining us. I think we're still expecting Sean, although he's late to the party. I'm Andy Fowler. We have Natalia Oleg Rice from Florida and Scott Horne. Scott, can you hear us okay?
I got you. Cool, man.
All right, good to see
You
you.
say it's
Here,
Natalia?
Natalia. Yeah,
Natalia, yeah.
yeah.
I better
You've
write
met her.
that down. I will forget it, Natalia.
Yeah, you've met her before. You just got a bad memory.
I got a bad lots of things, mister. Let me just
Yeah,
tell you.
yeah,
It starts from here and it goes all the way down to the feet.
yeah.
That's unfortunate.
I'm kidding.
Natalia, last week we spent a little bit of time about talking about the real estate market more generally,
Mhm.
but we haven't talked with you in a few weeks. What's the temperature like in Florida right now?
Ooh,
Not
okay.
not the
So,
physical temperature, though you can tell us
no,
that
yeah.
too, but the real estate market temperature.
So, real estate market wise, what I've noticed is that home prices are continuing to get slashed. So, we've had this trend over the past year where people list their property and then things don't move in 30 days and then they start cutting 20, 30, 40, $50,000. But what I'm seeing right now on average in the market, I mean, there's many properties that are 60 to 90-day waiting period from listing. Hmm.
Hmm, interesting.
It's getting back to normal, as I call it, right?
Yeah, I think the bubble's bursting a bit here in Florida.
I think so many people are so accustomed to things just flying off the shelf in a heartbeat, and there's so many, for lack of a better word, newbies in the business. And that's all they've experienced is this amazing upswing in the marketplace. And so few have been in the marketplace back when things take a little bit longer to transact and close. And for me, it's just it's normal. In fact, years ago when you had 50 offers on one property in 2 days, it was a nutcase. It was horrible. We all hated that.
Yeah.
The title company hated it. The law firm hated it. The investment world didn't like it. Well, some of the investment world liked it. The realtors hated it. Everybody did. It was terrible. Well, there's Sean. You back from ice fishing already?
Yeah, we ended early today.
Okay. But for me, I go back to the late 80s, early not through the 90s and early 2000s. Even the subprime days, things weren't flying off the shelves like they were. In fact, I go back into our, hard money days. And I say hard money, our much bigger hard money days. And so many people think that houses are just going to blow off the shelf, even in the hard money days. They think that your house is going to sell in 30 days. But the average time out of 4,000 hard money loans that we did, the average time a loan was on the books was 7.4 months, not 30 days, not 60 days. And people don't know that today. They've forgotten just how ordinary the business is. 60 days, 90 days on the shelf is not abnormal. It's much more normal. And we'll see how that flies. Even in Florida, which is where everybody's moving to, and to Texas and to Arizona as well, I think. And we see the same thing here.
Yeah, if you're just now joining us, this is the Creative Finance Collective. We're waiting for folks to join. If you have questions about creative finance, we're here to take them, and we're here as long as we have the questions. And if we stop getting questions, then we move on with our day. So it's important for you to engage. Since we started the show, we've also had Drew join us, although he joined us and walked away, but he's here and he's our representative from Georgia and Alabama. And then we have Sean St. Clair also, who is on today. If you guys who just joined us, Natalia was giving us kind of a temperature of the market in Florida, and there's been some a little bit of maybe uh, price drop as people are trying to feel things out. Scott, I've heard the same kind of thing about places like Austin, and I don't know if you've seen that, or I also we interviewed an investor recently that also said they can't get enough of buying in Austin. So I don't know what's true in Texas
You
or
know,
whatever else.
Heck, Andy. So Austin is little California here in Texas, pretty much. For gosh, since 1996, I've had a rule: I will not buy in central Austin proper because the prices were as California-esque as you could get, 3 times the price of Dallas properties in Austin. And from a risk scenario, if you're looking at it from an investor scenario, you just kind of go, yeah, no. I'd rather do 3 deals in Dallas versus 1 deal in Austin, just because you can spread the risk out so much better. And it hasn't changed any. And so you kind of got some swings in Austin also back in the day, kind of like you got in California a little bit. And I don't want those kind of swings. I want much more consistent type transactions that helps me sleep at night.
Yeah.
Oh, I do have an update regarding condominiums because that's something that's changed substantially here in the state of Florida.
Sure.
And those
Y'all
prices,
got condos in Florida?
yeah, condos in Florida. So that market has been significantly crushed due to the legislation that passed as a result of, I don't know if you all remember the national news of that building collapsing in Miami.
Okay.
So, Florida legislature took action, and now pretty much every condominium association has got to get certain inspections done. And we don't have enough engineers in the state of Florida to cover all of the condominiums that exist. These all have to be done by the end of this year. And if not, they start getting assessed fines, penalties, etc. So anyone who had a condominium out on the market, they're not selling, or they're selling for 50 to 60 to even 70% less than what people originally listed them for.
Wow.
Like significant depression in the market. And in response to those, the new legislation, the associations have had to figure out a way to collect the fees to pay for these engineering reports and all of that. And so the fees have tripled in so many condominium associations. It's a really bad time to invest in condos in Florida.
Wow.
I wouldn't recommend it.
That almost feels like as a commercial developer, or an owner, like a forced phase 1 study that you're going to fail. Everybody's got to do the work to improve it. I do remember that was like I do remember that collapse. That was a couple years ago, and was it even in result to a storm, or was just the building?
It just
Nope, the
happened.
building just failed. Yep.
Wow.
Well,
Or
talking about
construction.
Austin and condos, go take a picture of downtown Austin today. They've got 5 major high-rise condos going up right now. 60 stories plus. Boom.
All right. Well, we do have a question from a listener, and it is a creative finance related question. How much time will a lender typically provide to cure a default under the due on sale clause? So they bought at subto, they get some sort of notice, presumably from the lender. I'm not sure we can certainly put a time on it. Some of those things could depend on the contract itself. What do you think would be reasonable to expect that this person has to cure that?
It depends.
Depends. Yeah, it depends on a lot of things.
Yeah,
So
most,
I mean,
90% of the due on sale clauses is going to give you 30 days notice. So Fannie Mae, Freddie Mac, FHA, they're all going to give you 30 days notice. 90% of the time, that's what the actual deed of trust states or mortgage states, but there's no set law on it.
Well, let's talk.
And then
reality.
after the 30-day notice, they're going to give you another 30 days to accelerate, and then they're going to start foreclosure proceedings, which is at least another 30 days. So, I mean, you're looking at like a minimum, I think, of 90 days before you could even contemplate getting to a foreclosure.
Oh, you guys talk like such lawyers. You know it? I get what the deeds of trust say and the law says. Let's talk about practicality.
It's
4
usually
to 6
longer.
months.
Yeah, it's usually longer.
At least. They'll send a letter out, they forget about you, they don't do anything, then they'll send a follow-up letter back out, and maybe a third follow-up letter. It doesn't mean you don't want to pay attention to it, because yes, they can do just what Sean, was talking about as per the deed of trust and those kind of things very quickly. But what I have seen when those things come down is, although it can happen that quickly, and especially here in Texas, it can happen quickly. but typically it's going to be, I've seen minimum for 6 months and longer.
Now, of course, we're talking about traditional banks. They'll
Yeah.
take their sweet time.
Oh,
If
yeah.
you've got, a private lender or a hard money lender, and they're concerned with their due on sale clause, they're going to be a lot faster.
Well, I did mine for 21 days last time when I found that out.
Mm-hmm.
That's how fast I did mine. So Texas is great for foreclosures.
All right. We have another question. Sean's gone dark. This question was for him. Let's see. It says, Sean has mentioned in the past that you can't have anonymity with a land trust in Arizona. What is an alternative structure? So before we go to that, and if he comes back, we'll get to him. There are reasons why land trusts have issues with anonymity here in Arizona, and that's mainly because we have a statute that requires when property is conveyed into and outside of a trust, we have to disclose the beneficiaries of that trust on the deed itself. So of course that becomes a matter of public record, and thereby now you have a potential issue. I know up in Florida, Natalia, you've got an entire statutory body
Mm-hmm.
of law relating to land trust. Is there any issue with using the land trust and maintaining anonymity? I presume it allows it in the statutes.
No, in Florida, it's pretty investor friendly, the statute. So there's nothing requiring us to record like who's a part of what when it comes to land trusts. But I do warn my investor clients as a result of Sean's education regarding acquiring property in Arizona and going a different route.
Yeah. Sean, while you were out, we got a question directed directly to you, and I'll read it to you again. But Sean has mentioned in the past that you can't have anonymity with a land trust in Arizona. What is an alternative structure? So if you really want the anonymity, how do you like to go about it? In Arizona.
I mean, in Arizona, you can buy in the name of a Arizona LLC that's either owned by a holding company out of Wyoming, for example, or Delaware that has anonymity, or you can buy in the name of an Arizona LLC that's owned by what I call a membership interest holding trust, similar to a land trust, but it's created for the purposes of owning an LLC membership, and it has an anonymous name, whether it's the street address, the Sun Devil Trust, whatever you want to call it, and that would be the owner of the LLC, and then nobody would know who owns the LLC. Now you're not putting it into a trust, but do you need to put it into a trust? I don't think you need to. I'm not a huge, proponent of that. Some people think you should put it into a trust to avoid due on sale issues, because by putting it into a trust, you make the lender think that Horne St. Germain's being complied with. But if you want anonymity, you could just use an Arizona LLC, either with an anonymous LLC that's the holding company, or as a trust, or owned by a trust that's anonymous.
No issues. Any issues with anonymity in Texas with the land trust, Scott, or
No.
not a problem?
So Sean, say that one more time about
So
you create the anonymity, or you try to get that in Arizona.
yeah, I mean, assuming you are willing to buy in an LLC and you want anonymity, you basically form an Arizona LLC that's either owned by a Wyoming LLC,
Okay, yeah.
or you form an Arizona LLC that's owned by a trust that has an anonymous name. So like the Sun Devil Trust, or the street property address, or whatever name you want to give the trust, and then that trust owns that Arizona LLC. And you want to do an Arizona LLC because we've had clients make this mistake, as opposed to buying it directly in a Wyoming LLC, because let's say you buy a rental in a Wyoming LLC, tenant stops paying, and now you need to access the court to evict. our laws in Arizona state that you cannot access the court unless you've domesticated your entity, your foreign entity, to do business in Arizona. Well, if you then have your Wyoming LLC that owns the property and now you want to file a lawsuit, so you need to domesticate, and you go and you file with our corporation commission, well, guess what? We're not an anonymity state. So now you're disclosing all the members, managers, et cetera, of that Wyoming LLC. So if you start off with the Arizona LLC being owned by the Wyoming or Delaware LLC, you never have to worry about that because it's an Arizona LLC to begin with.
So I was just going to ask you that exact question. If that Wyoming LLC had to register at a foreign entity there in Arizona, and the answer is yes. So it just,
only if it's the one that owns the property and is going to be the plaintiff on a lawsuit.
right.
But if
your Wyoming LLC is the owner of the Arizona LLC, does it not have to register at all to do business?
That's correct. The Wyoming LLC does not have to register.
Got it. Good to know. Damn, you're smart.
Some days.
Really complicate things.
Sean, with respect to why the land trusts get used in Florida, is because that statute specifically limits liability for the trustee and for the beneficiaries. So it is an asset protection type of trust, which is not the case for all the states that allow, creating a land trust. It just happens to be a very investor friendly one. With respect to here for in-rem proceedings, you don't need to do domestication for businesses for the lawsuits.
Good. So I have a question for you, Natalia. I've gone round and round with people on social media about this. I probably spend way too much time in brain cells doing it. But there's people out there, these gurus, and now we're going to put the statutory land trust aside for a minute. But there's these gurus out there who are suggesting not statutory land trust, but revocable trusts. They're suggesting that the way to set up a land trust and to, handle a property transaction, subject to or otherwise, with a land trust is to have the seller be the grantor of the land trust, have the seller move the asset, the real estate, into the land trust. Then once it's moved, then simply assign the beneficial interest of the revocable trust to the buyer. And I'm like, there's no way I would ever do that.
That's not a completed transfer in a revocable trust, in a regular revocable trust. Yeah.
That's part of it. And then second is you're still giving the seller control over the trust, because if it's revocable, they still maintain control. And
Exactly.
Number two, at least Arizona, and I think Texas and Wisconsin has the same. I know Wisconsin does. There's a statute that says the seller or the trust and any property the seller puts into the trust remains liable for the debts and obligations of the seller for their lifetime.
Correct. There's no self-settling
Yes.
trust allowed in Florida, and the only exception that's that unique tool is the Florida Land Trust Act.
Right.
So a standard revocable trust
right.
isn't going to do it.
Yeah, and there's these gurus running around telling everybody to do it this way. I'm like, no. Now, I do think that you can, as a buyer, create a trust and make that trust be, and you fund it, put $100 in the bank account, and then make that trust be the buyer on the purchase contract, and then buy it, and you can play games with the trustees and seller and whatever for anonymity purposes, and then amend or have them resign later on. But I do not think it's appropriate at all for the seller. I'm glad you agree with me, because, these folks on social media want to play lawyer, and it drives me crazy.
Yeah.
Sean, you sound like you're getting
All
on
right,
my
if you're just now joining
soapbox
it.
about land trusts.
No. Give it to us, Drew. What's your soapbox? You don't like them.
No, I've given it enough, but I want to point out that people from Florida obviously buy up in Georgia regularly, and I do run into your land trusts. And Georgia and Alabama both, every effort should be made to file a trust certificate of record, almost as an exhibit to your deed. So generally, the way these things are designed, you have no anonymity. If you want anonymity, just form an LLC and set up an authorized signer and call it a day. But it's funny to see, just as Sean was saying, you have these gurus, they set these things up. These people generally come out of Florida, and all of a sudden I'm busting their anonymity. anonymity open because I need to file a certificate of trust that is statutorily, sort of dictates what I need for title purposes. And I'm going to put who the grantor is. I'm going to put who the trustee is. I'm going to put who the successor trustee is. If your little trust requires the beneficiary has to approve any transaction in writing, guess what? That's going to be in it too, right? So it's just the different states, they kind of go all different ways on this. And they're like, well, I need it. I'm like, just form an LLC in Georgia and Alabama. They will request that you label the members and the managers, but there's no legal requirement to fill it in. You can leave it blank, which generally we do. And then you just set up an authorized signer and you're done. You've got the anonymity you're looking for in our states. And like Texas, if you're just a landlord, there's no requirement to domesticate in order to handle eviction or a lawsuit. So you don't have to fool with that. You can be an out-of-state landlord, and if you need to evict, go for it.
Yeah, I would add that it's really important that no matter where you are investing, you have local counsel review the transaction before you do whatever you're going to do. Because like we are composed of 50 unique little jurisdictions plus DC. They all have their little quirks. And real property law is just so specific to the region that you need to have local counsel. So if you're growing out of a specific state, go get local counsel, which is why, Sean, Andy, what's the name of the Facebook group that you guys have created for the investor community so that they can find local counsel?
Yeah, Sean's
Yeah.
group, Real Estate
Investor Legal is what it is. I'll type it in the chat here. Real Estate Investor Legal. Yeah, thank you for mentioning that.
Yeah, the getting local counsel is so huge. I mean, you use the example of our border state. One of the states we border is Colorado, and Colorado has significant penalties relating to certain types of properties and foreclosures if you don't do that right. And if you think you're just going to go get forms from a guru and just jump across one state line and think you're going to be okay, yeah, you got another thing coming. All right, so if you're just now joining us, this is the Creative Finance Collective. We're taking questions for as long as we get them, so it's important to ask away as we're here. We have another Creative Finance question. What are my options if a sub-2 seller refuses to cooperate or speak to me after closing? So close the deal, you bought sub-2, the seller goes dark. You may not need them right away, but their name's going to be on a lot of documents. Sean, my first thought is if you transacted this right and got the right documents, you probably don't have to do a whole lot. What do you think?
Yeah, I mean, I think I'll defer to Scott on this. He, I think, has a set of forms. He has the seller sign that would be, pretty beneficial or helpful. So I'll let Scott fill us in.
Well, you have to forgive me. I was kind of muted there, so you got to ask that question again.
Yeah, let me give you the question again there, Scott. It's what are my options if a sub-2 seller refuses to cooperate or speak to me after closing? They've gone dark after closing, and you need them for whatever reason. My initial thought to Sean and statement was, if you transacted this right, you might not worry too much about that. But what do you think?
No, you're exactly right. When you contract for it correctly, you've got a proper limited power of attorney, authorization form. You get all the information you need up front. You don't need that seller anymore. And oftentimes these sellers, they do go dark. They're in financial distress. They're doing this or doing that. They're moving. They want this out of their hair. And so if you've got good documentation, good closing docs, you're okay. And you don't need that seller really for any reason whatsoever that I can think
I would
of
raise an
offhand.
issue though. If the power is revocable, you've got an issue.
Well, they can revoke a POA. Yes, ma'am. I totally agree with that. And I've had one or two do that.
I've just seen a couple, but just enough to be.
But you still have the authorization form and items of that nature that are out there they've executed. And so I will say for the great part, and I don't know, I've closed so many thousands of these deals, something almost north of 10,000 of these things. And it's happened maybe 2 or 3 times. They just don't do it too often. But you are exactly right. They can do it. They can try to get persnickety. What happens is they'll call up. I had one guy, just to give an example, where the investor had bought the house 2 years previously, brought the seller out of foreclosure, got everything reinstated, renovated the home, making payments on time, had been leasing the home, decides to do a seller finance. Somehow the seller finds out about it, that this investor is actually making money, and comes back and goes, well, I deserve more money, and cancels the POA and those kind of items. And, hopefully they've got everything online set up properly, which that person can go back and change. Had that happen too. And, at some point in time in this industry, it is what it is. It's just, an assumption of the risk that sometimes things can happen that you can't control.
Yeah,
I think you just have to recognize those things.
I've seen revocation of the POAs when, usually not that long after, but when they discover that there's money to be made, and they decide somebody else came along and made a different offer, and they want to go with that offer, and so they start revoking at that point. But you do have to be mindful of that. Yes, that is a risk that you take, in the subject to, and that's probably why you don't necessarily want to hold on to these subject to ones for a very long time. The faster you get, these people's mortgages paid off, and like just take that money, take the equity built in, and get yourself another separate deal, I think the less risk you have, because you're not managing these mortgages for other people.
Yep. You brought up the money part again. It's just like a probate scenario with heirs. Long lost heirs just come out of the woodwork when there might be money on the table and everybody's got their hand out, deservedly or not. And it's the same way with this stuff sometimes as well. And it's just, you try to teach the investor community to be mindful, just as you said, Natalia, that this is just one of the things that can happen. It does happen. Not often, but it does, and it can. And just make sure you've done things as best as possible. Try to be as nice as possible to your sellers as well. Take care of them appropriately. And from there, that's all you can do, I think.
Yep.
Yeah, it's one of those problems you just have to accept the risk on. I mean, outside of that, the only thing beyond that is I guess that would be considered a breach of some cooperation clause within the contract. But, at the end of the day, what are you left with there? An action for breach of, failing to cooperate. That's not going to get you real far. It's not going to get you real far in a short period of time. That's for sure.
It's going to spend a lot of money on attorney's fees for somebody.
All right. If you're just now joining us, we're taking creative finance questions. So make sure to post them in the chat. We have another question. I think this is a due on sale clause type question, though it doesn't say due on sale. Are there any lenders that you would never take a property subject to? And maybe, I don't know if they're asking specific lenders versus types of lenders, but I don't know. What do you guys think? Is there a situation where you could see a particular type of lender, a certain lender, and you're like, I wouldn't do this deal?
Yes. There is a type of loan that's been taking place in your old states too. I definitely saw it in Arizona, out west, in a couple of states, but it's happening here in Florida. And they're types of loans that I would say target elderly populations. So these are equity loans where the lender is both recording a mortgage and they're usually small sums, okay, 30, 40, 50K, but they are retaining, quote unquote, an equity interest in the property, or they have purchased an option and the loan amount that they're giving is an option. So there is a lender that starts with a U out there who's currently being investigated. So if you see these kind of like recorded mortgage instruments that say, but we're not a mortgage, but we're a mortgage, but we have an equity interest, etc. I would steer clear of those.
Is that going to be mostly private, Natalia? That you see in that
I mean,
regard,
they're
or
big
what?
companies.
kind
They're not, it's not a Wells Fargo or something like that, but they're,
Yeah, I can see some private guys out there trying to carry back rights of first refusals and those kind of items along the way. And I think it's a matter of actually taking a minute and reading your note, reading your deed of trust, if you're doing that and knowing what it is you're taking subject to per se. And if you see that in there, oh, heck yeah. No, run for the hills. Or get
Another
it
kind are
released,
the
one or the other.
loan-to-own shops. Yeah, if you see a lender that's part of a loan-to-own outfit, I mean, they're going to look for every excuse they can to take over the asset, and you're just going to hand it to them on a silver platter if you do that.
yeah. I'd also probably steer clear of oh my goodness. Just let my story. The ones that are purchased by HUD or reverse mortgages. HUD's not a fun negotiator. They don't like doing it. They don't even take decent. I mean, they're just not the best.
Let me make a couple of comments about that real quick, guys. So, on a reverse mortgage, I'm sure we all know, and I'm sure the rules and regulations are the same everywhere, where the loan comes due, 12 months after the death of the last spouse, or 12 months after the last of the spouses vacates the property. Got it. And so can you take that property subject to that debt? You can. And if you're going to play that game, you better dang well know what the loan balance is, because as we know, it keeps increasing every month and the interest rates are adjustable. And you want to make certain you have current data on that to know exactly what you're doing. And if you do that, that's fine, but you better be prepared to refinance it, sell it, cash out of it in some format within that time frame, because they can call it due. I will tell you guys, I have one that I did years ago, still have it, and have now paid that loan down about 70% from its original value. And so far, everybody's happy because they're getting all their money, all their principal, and things of that nature along the way, along with their interest. I keep waiting for that notice to show up that, no, the loan's being called due. It just hasn't come. And that might be a 1 in a million type deal. Maybe we just got lucky. I get it. Sometimes better to be lucky than good in this business. But every once in a while you get lucky. But I think if you go into it, you better go in with your eyes wide open, realize what it is, because for the most part, they are going to call that loan due and start their foreclosure proceedings.
And it's always more expensive than you think. I'll just add that.
Oh, heck yeah.
Mm-hmm.
But it really
All right,
is.
good info. If you're just joining us, this is the Creative Finance Collective. Make sure to post your questions in the chat. We're going to get to those as we get them. Another question here from YouTube. Can I contractually penalize the seller in a subto transaction from telling the lender about the sale? I think this is getting at botching or telling the lender out of spite because maybe they didn't think something was disclosed. Can you contractually penalize them for that? I suspect a creative transactional lawyer could do that. I just wonder, where does that get you? Have you guys even seen anything like that?
You can put anything you want to in a contract. And, they go out and they want to cut off their nose to spite their face, right? Because if they contact their lender and this thing's getting foreclosed upon because of whatever they're doing, the lender calls the loan due. It's not me. If I'm the investor getting foreclosed on, it's them. Okay, grant you, I might have money at risk in those kind of things, but it's not me. And so again, we try just to simply educate that seller on these kind of things, hopefully help them be a little bit more intelligent about that. Let them realize that really they're only harming themselves in those instances. But again, you can't idiot-proof every deal out there, unfortunately, because sometimes that idiot factor just exists.
Yeah, I like that. There's Yeah, it's kind of like the question, you know, when something is not lawful or the law doesn't allow it, but people do it anyway, and they're like, well, how did they do that? How on earth can that possibly happen? The law says they can't do that or whatever else. And it's like, well, unfortunately, when the law says something and somebody doesn't follow it, lightning doesn't come down and strike them dead for not following the law. They did it. Now what? What are you going to do about it? And that's just, like you said, you can't idiot proof a contract. So I'm not even sure what it would get you, other than putting language in that in a contract like that might create kind of a level of distrust during the negotiation period that maybe you don't want. And the better practice is to disclose, and be proactive about disclosing on the front end what's happening, what they should expect as part of the creative finance transaction.
Andy, one of the things about that is even if you have these clauses in there, they breach the contract and you're going to sue them. What in the world are you going to get? A cease and desist order? Great. Too late. They've already done it. Damages? Yeah, good luck collecting. We all know it's easy to win the battle, but you still lose the war, because you can get those judgments all day long. You just can't collect anything in so many cases. And for lack of a better word, as you say here in Texas, you're just pissing in the wind and it's not worth doing anything. And nobody wants to hear that, but that's just the cold, hard facts sometimes.
Yeah. Makes sense. Sometimes I think you can overthink things.
I can guarantee you one thing: you will win.
And I think one of the lessons here is these are transactions. Even a conventional transaction has some risk associated with it. The marketplace has some level of risk associated with it. A creative finance transaction is not a conventional everyday transaction, and there is risk associated with it. And if you're not prepared or ready to deal with what may come, then you're probably not in the right business. I think it's safe to say.
And I think, guys, just to kind of top that off, Andy, so many investors get into the business not realizing that. They don't have the financial ability to carry a debt load in the event something does go awry, because things do go awry in this business. I don't care who you are or what you are. You may get lucky your first time, your 10th time, but that 11th time, poof, things happen in real life. And so many of these investors, when they get involved in this business, they're not prepared for that. They think it's going to be just this easy breezy, transaction with mailbox money just rolling in the door, and you don't need to do anything. And absolutely not the case.
Good information. All right, ladies and gentlemen. Well, we've gone through all the questions that we have today. I don't want to. I know your afternoons are precious. You've got families, you've got work, and so we appreciate you taking the time with us. But since we've got through the questions, we'll call it. So thanks for joining us. Hope to see as many of you can make it next week, and go be productive.
All right.
We'll look forward to it.
Okay.
Andy, I will make one comment. Just opened our title
Okay.
office in San Antonio. Did that last Friday. It's like I keep trying to slow down on what we do. We create more headaches.
Now, how
and
many
more
offices
problems.
is that for you now? 47.
47.
Okay.
No,
It's
I'm
like
kidding.
we're running out of states here. Okay.
No, it's only 4. But anyway,
All right.
all fun stuff. I think we let Sean go back to his
Back
ice
out
fishing.
there in the water. All
It was
right.
nice to see you, gentlemen.
Yeah, thanks. Good to see you, Natalia, Scott, Drew, Sean. We'll see you next time.
All right. Thank you all.
Bye, everyone.
right.
Bye, guys.